Rural landowners often get payments from companies for right-of-ways or easements on their property. However, the receipt of an easement payment can raise some tax issues for farmers. Roger McEowen with the Washburn School of Law joins us now with a closer look into this. And Roger, give us a little background on this topic.
Well, hi, Tammy. Good to be with you today. It is true that rural landowners receive quite often payments from such things as utility companies or oil pipeline companies or wind energy companies for rights of way or easements over their property. And so that's a big issue for a lot of farmers and ranchers and rural landowners all across the country.
And I know that we're looking at some main types of payments there. Talk a little bit about that.
Well, the payments can vary. They can take the form of damage payments. It could be for an access right that's limited in nature rather than a very large right. Of course, if you have crop damage, there'll be a payment for crop damage. That can be a type of payment that's involved. It could constitute a sale of the property or severance damages or even a negative easement. We often see those with respect to environmental concerns, such as a payment to not use my property in a certain way to protect certain types of species or a wetland area. So they really vary in terms of the type of payments that a rural landowner might receive.
What are some tax issues that might arise from this?
Well, the big one is in terms of characterizing the transaction. If all you're retaining is what we call bare naked legal title to the property and all of the use rights have been given up, that's really a sale of the property for purposes of taxation. It's not receipt of a lease payment, which might be classified as royalty income. So we really have to peel the cover back on the transaction to determine what rights in the property the landowner has retained. Any
examples you can share with us?
Oh, there have been a lot of cases over the years, and there continue to be just about on a monthly basis out of the tax court and elsewhere that construe the nature of the transaction and the property right that's retained and how much of the property is affected. Because if it affects a good percentage of your property, you can probably offset the payment by your land basis. And that's what the cases teach us on this.
What would you say the big takeaway is here?
This is another one of these that when you're approached with an agreement for an easement on your property, you probably should have a couple of people look at it. Have an attorney evaluate the language in the deed that purports to take the easement or have you grant the easement to them, and then have also a tax person. It might be the same person, but have somebody look at it from a tax angle to unwind those characteristics for you too.
All right, good information. That's Roger McEowen with the Washburn School of Law. Appreciate your time and input today.